Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and in this video, we are talking about the differences between the I-485 and consular processing. So as you know from previous videos, there are three major stages in the employment-based green card process based on a perm labor certification. The first stage is, of course, the perm labor certification process itself. The second is the I-140 petition, and the third is applying for a green card, which would be either the I-485, also called the adjustment of status, or consular processing. So a person can choose one or the other. Let's talk about what those mean and what the differences are. The I-485 is the name of the form that a person submits if they are applying for a green card from here in the United States. We submit the form I-485 to USCIS, the immigration agency here in the United States, and a person must be physically present in the United States when we file the I-485. If they're outside of the United States and they don't plan to come in to file it, then, or if they're not able to, then we have to use consular processing. The I-485, in order to submit the I-485, the priority date has to be current, either per the final action date or per dates for filing, depending on which of those dates USCIS is using in any given month. But in general, the priority date has to be current. In addition, the I-140 petition does not have to be approved in order for you to file the I-485. It's very common for our clients to file the I-140 petition concurrently with the I-485 application, or for the I-140 petition to be pending and processed with USCIS not yet approved. The priority date becomes current, and then the client chooses to file the I-485. It's of course possible to wait for the I-140 petition to be approved first as well, or maybe that's happened anyway. When we submit the I-485, we submit an I-485 form and package of other forms and supporting documentation for each family member that is part of the green card process. So for example, if you have a primary applicant who is the beneficiary of the perm labor certification and the I-140, that person can include their spouse and minor children in the green card application processes, and each one of those persons will have their own separate I-485. When we submit an I-485, we can also apply for a work permit, also called an employment authorization document, and a travel permit, also called the advance parole. So once the I-485 is filed, it is possible to use the employment authorization document to be able to work in the United States, or the travel document, the advance parole, to be able to travel outside of the United States and re-enter. Of course, this is not immigration advice, this is not legal advice, so you have to make sure that you speak with your immigration attorney before taking any action. Keep in mind that if you file the I-485 here in the United States, depending on your particular situation, that may restrict your travel. In other words, you may not be able to leave the United States and re-enter, at least until you have that advance parole document approved, while the I-485 is pending. That could be okay for you, but just keep in mind that it may restrict travel. On the other hand, filing the I-485 here in the United States, if you're able to, might be less disruptive. A lot of times we file for families where children, minor children, are in school, whether they're US citizens or they're actually applying for the green card itself, but we have situations where people are in school or they can't leave work to go overseas for a few weeks at a time, and they are more inclined to stay here and file the I-485 here in the United States. One question we frequently get is what happens if the priority date retrogresses? So I said a minute ago, the priority date has to be current for you to file the I-485, again, either per dates for filing or final action dates, depending on what USCIS accepts at the time. But a lot of times it's possible for that priority date to retrogress, meaning to not be current anymore. If that happens and your I-485 is pending, it will remain in abeyance. That's a term that means that it will remain pending. And you can continue, USCIS will continue to process your employment authorization document and your advance parole document while, even if the priority date has retrogressed. So the case will stay pending with USCIS, but it cannot and will not be approved until the priority date is current per the final action dates. So that's the information about the I-485, also called the application for adjustment of status, or the green card filing is often what people call it. The other alternative is consular processing. So know that this selection, whether we're going to do, or you are going to do the I-485 or consular processing, we have to indicate that on the I-140 petition. It can be changed, but depending on the situation, that can cause some delays. But generally it's determined at the I-140 stage of the process. So consular processing means that the foreign national, the beneficiary of the perm and the I-140, is going to apply for what's called an immigrant visa at the US consulate overseas. That means that that person is going to have an interview at the US consulate. You have to have a medical exam done beforehand. There's some documents that you have to upload to the National Visa Center beforehand. It's a process. But in general, it means that the foreign national is going to have that interview overseas at a US consulate rather than waiting out the process here in the United States. That can be done because the foreign national is living overseas. So for example, we have a lot of clients who have tried the H-1B lottery several years, haven't been selected yet, and they are already overseas. They are working remotely for the US-based employer, and so they just pursue the immigrant visa. They pursue consular processing overseas. So it can be because you're already there, you're already living overseas, or you can be physically present in the US and choose consular processing for any number of strategic or personal reasons. So like I said, you have to have an interview at the US consulate. Once you receive that immigrant visa, you will use that visa to enter the United States. And again, like the I-485 process, family members, of course, can be included. They will have their own immigrant visa cases. You may be interviewed together, you may be interviewed separately, but you each have to apply for your own immigrant visa in this particular situation, but you will use that immigrant visa to enter the United States. Once you enter the United States, you should receive the green card in the mail within about 1 to 6 months after entering the United States. This particular option does require, of course, a person to be in their home country or another relevant country. Typically, it's your country of residence, your last country of residence, or where you're a citizen. So it does require that you be in that country for a period of time. It depends on how long the process takes. Typically, I advise clients to plan to be in that particular country for at least a month. So that can be disruptive to their lives here in the US if they're already living in the US. For school reasons, professional reasons, all kinds of reasons, they may choose to not do that and submit the I-485 instead. There are travel costs as well. In general, the process is less expensive as of now in terms of filing fees, the government filing fees. But you have to consider other factors as well, including travel costs and time that you would have to spend outside of the United States. It is possible in some instances, I mentioned strategic reasons for choosing consular processing instead of the I-485, depending on previous immigration violations, status questions, things like that. Sometimes consular processing is a better option, but again, make sure you talk to your immigration attorney before you make that decision. That is the end of this particular video. I hope you found that helpful and that you will share this video with a friend or family member. Make sure that you subscribe to our channel and you turn on that button for alerts so you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We serve clients around the United States and from around the world with family-based and employment-based immigration matters. Until next time.